Hey, everybody. A little bit of a privacy party for us here this Friday. I was not going to do this week. I was supposed to be in Israel, but it's hard to get into Israel now, so my trip is delayed. I'm leaving Sunday for Tel Aviv University's Cyber Week, which is always a fun event that brings people from all over the world to yak about cybersecurity and increasingly privacy. So impromptu, though, because of some really interesting news this week. Most recently, the update from the California AG that gives more certainty that the global privacy control and concepts like that are here and real and are legally required, as well as word that the AG has been sending out letters taking a look at some of the nuts and bolts of how people are or aren't well complying with the do not sell mandates, particularly, at least from a couple of the pieces that have trickled out related to the cookie tracking, the behavioral tracking, and evidently even the global privacy control has been raised as a question to some of those players. So was delighted at the last minute, one of the originators of this incarnation of the global privacy control. Presumably there can be many, but this is the one that's been put out most prominently. We'll ask for an update on that, but we've got Ashkan Soltanito, longtime researcher, expert, consultant, advisor, and thinker on these issues. Also other members of the FPF team, Verdi, Stacey Gray, Gabriela Zanfir-Fortuna, hopefully familiar to you all. We're going to start with the news that was perhaps last week's news. Is it already a week ago, 2 weeks ago? The big executive order from the White House, and to unpack a little bit about what it means when it comes to privacy and data protection. There's a lot in there for the administration in general, and there's clearly a very big competition focus, but quite a few very specific issues that are all about data protection for our particular interest. So let's run through it. Stacey and Gabriela just put out a post where they summarize some of the key areas that involve data protection. Let me ask you two to turn to it. Gabriela was struck particularly by the way the European and US conversation around big data collectors seems to be converging. Ashkan obviously spent time at the White House and at the FTC and is going to have perspectives on this as well. So Stacey, to you for what were the key things in there. We'll post a link in the comments here as well. And folks, throw in questions. We're watching the LinkedIn comments if you want to ask Ashkan, if you're an implementer in particular of the GPC and you think it's very hard or complicated or want to understand where the spec is, we're going to turn to that. So feel free to throw questions in to the comments. Stacey.
Cool. Well, yes, thanks, Jules. People should check out our summary if they want the longer summarized version of the executive order from last week. Pretty exciting move from the executive branch. It's a whole of government approach to pro-competition policy, meaning that it instructs federal agencies across the board to either conduct studies, take actions, consider taking actions, consider commencing rulemaking, or otherwise incorporate the policy of the administration to aggressively bring antitrust enforcement in line with earlier century, Sherman Act and Clayton Act type antitrust policy. The exciting parts for data protection and privacy are one, that the executive order explicitly frames accumulation of data as a sort of a core or integral part of antitrust and competition policy. And that's a really big deal. The policy of the EO explicitly talks about attention markets, surveillance of users, and presence of network effects. Probably the second biggest thing for privacy professionals is that it encourages the Federal Trade Commission to undergo rulemaking in a number of areas that are related to antitrust, including things that are tangential, like right to repair, but more specifically to address unfair data collection and surveillance practices that damage competition, autonomy, and consumer privacy. So again, a big deal. We already know from the current FTC with the new antitrust expert, Lena Khan, as the chair, that this is kind of the direction that they're going. And future rulemaking is probably going to be done under Magnuson-Moss, slower agency procedures. But we might get some more rulemaking out of the FTC around what it means to engage in an unfair data practice. So that's huge. And all of this aligns with growing trends in the European Union, which Gabriela is going to speak to a little bit. And then finally, because again, this is a whole of government approach, you might not have noticed if you took a look at the fact sheet last week that the executive order also tasks a number of other federal agencies with doing things that are relevant to privacy and data protection. So, for example, the Department of Transportation is going to be working on issues related to privacy and drones. The Department of Commerce is tasked with conducting a study of the mobile app ecosystem. The FTC and the Department of Defense are doing things around right to repair. We've seen a revival of net neutrality. Potentially, the FCC is encouraged to consider reviving net neutrality rules similar to those that we saw from a few years back. And finally, the Consumer Financial Protection Bureau is encouraged to consider rulemaking to facilitate financial data portability, which is, of course, something that they're already working on, but again, encouraged to consider doing more. So lots there for data protection and privacy.
So, John, you were at Commerce helping lead the privacy initiatives. Help folks who are global and wondering what you mean executive order here. This is sometimes binding with the force of law against an agency. It's sometimes go figure things out. What should folks who want to understand the legal process involved know?
Sure. So the key distinction here is that the EO addresses two buckets of federal entities. On the one hand, there are cabinet level agencies, and those agencies answer to the president. The secretaries of Commerce and Defense and Transportation serve at the pleasure of the president. And from the secretaries of those agencies on down, an executive order means whatever that EO says to go and do, folks at those agencies need to run and go and do. That's your boss's boss's boss telling you to go do something. Sometimes the EO will ask an agency to go study something, and the agency then needs to go study it, or else they're going to hear from their boss or their boss's boss or all the way up the chain that they're not executing on a presidential priority. And that's not a good phone call to get if you're sitting at an agency like Commerce or Transportation. The second bucket, though, are independent agencies. And in our world, we typically think of them as independent commissions, like the Federal Trade Commission, the Federal Communications Commission. There are others. And those independent commissions have far more autonomy than the cabinet level agencies. And the president certainly appoints commissioners. But those commissioners and those chairs in the independent agencies have greater autonomy to set their agenda, to execute on priorities, to execute their statutorily defined missions as set forth by Congress. And it is not typical for a presidential executive order to compel an independent commission to do something. It is, as this EO does, not unheard of for a administration to suggest or to encourage an independent commission to go and do something. Now, this can be the matter of some political controversy in Washington, because independent commission ought to mean independent commission, right? But at the end of the day, it seems that this EO is encouraging independent commissions to take a particular approach to competition policy and to data protection. And it is, in fact, directing cabinet level agencies to go ahead and execute on studies, to perhaps initiate rulemaking, to produce reports, or to take particular actions that are within their already statutorily designated authority. So that's the distinction between independent commissions like the FTC and FCC and cabinet level agencies like the Department of Commerce, the Department of Transportation, and others.
So, Ashkan, I wonder your reaction, both on process, but on substance as well. I mean, I have been agitating for the Biden administration to help unblock the legislative, chokehold that seems to be preventing us from moving on. So, although super appreciative to see all these executive orders, but executive orders are what you do when you don't think you can do legislation sometimes. And sometimes you do them because, well, you're in charge and you get to order agencies, and it's a way to, formally execute on the administration's agenda. What did you take from this, from where you sit?
So I think John did a great job kind of summarizing the interests or the equities in that in kind of the process procedurally. I think the optics and kind of direction setting is important here too. So it's, a lot of what the brief time I was at the White House, a lot of what I would do is try to coordinate so that people are essentially aligned and, in fact, tracking towards the same outcome without necessarily recommending what the outcome is, but things like we should look at the intersection of competition and privacy, for example, or competition and data collection, right? And we should focus on this not just through legislation, but through the many related actions, both. So can't forget not only privacy legislation, but antitrust legislation, plus antitrust enforcement, plus kind of safe harbor stuff, right? So those are like a bunch of different, as well as competition with China, right? So those are all kind of different pieces on the plate right now in terms of policy that all touch data privacy, and competition. And so I think it's kind of setting a direction. The other thing that's, I think, worth noting is that, every 10 years we kind of come back to this, right? Separate from legislation, which we do discuss legislation every few years. But, if you look at, and you remember this well, Jules, because you were involved. So, late 90s or early 2000s, first debate, DoubleClick, online advertising, et cetera. Then 2009, FTC kind of staff report on behavioral advertising. And then about 10 years later, now we're kind of back to it and saying, like, maybe we should rethink things about the bargain we struck around notice and choice and around whether consumers are adequately informed around data collection. And I think the use of the term surveillance, right, I think really speaks to the fact that perhaps there is a recognition that there's not adequate knowledge and consent and choice with regards to these practices, and that agencies should look at what's going on. So I think it's kind of signaling and coordination, and as well as a recognition of the fact that, like, it's up for debate again. We do this every 10 years. Let's discuss it separate from congressional action.
It seems like there are two themes that are going to be clear about the Biden agenda on privacy and data protection. One, and this was perhaps evidenced in the early comments they made about data being needed for race and equity, worries about AI and discrimination. We want data for AI, we want data for disparity, but we also are worried about bias and equity and so forth. And I think we expect that we'll see commerce in the upcoming months starting to talk and look at the civil rights impact. And one imagines when it comes around to legislation, if we see the administration, which hasn't yet formally even said that it wants legislation and didn't say so in this executive order, and isn't yet on the record. I think we all expect that they will be from previous administration, from folks involved in the campaign, from the kinds of people that are at the table, and what perspective they'll bring. So certainly one of them imagines that they'll be very sensitive to the potential civil rights concerns and problems. And then the second one clearly seems to be driven by big tech, right? Which Congress, Democrat, Republican, this administration, and in this executive order, right? It's definitely animated by big tech, big data, what can and should be done. So those are probably compatible themes, but definitely different drivers than this. In Europe, the driver has been less about race and civil rights and equity, and more sort of a generalized human rights concern. Definitely a big competition and big tech concern, and then very specifically a surveillance advertising is bad, and we've seen many groups, not just sort of the hardest core anti-capitalism groups, signing on to letters saying ban surveillance advertising, and so Gabriela, what are you seeing a convergence here of views across U.S. and Europe in terms of the regulators, certainly civil society?
Yes, absolutely. And in fact, I was quite struck when I read first the fact sheet and then the executive order itself, because I identified at least two of the very, very big topics that were top of mind for regulators in Europe, not only in Brussels, and this is quite interesting, in the past, I would say, 10 years, 8 years or so. There has been a very big drive to converge competition policy with data protection rules in Europe. And for example, the EDPS published such a call in around 2014 in their opinion on big data and competitiveness, where the actual, the first sentence refers specifically to accumulation of data and the role that this plays in concentration of power on a market. And then this is one of the topics that I've seen as being really relevant in Europe. And then we've seen competition regulators in France, in Germany, that started to put reports together, looking at these issues, big data and dominance of markets. We've started to see actual action being taken. The German antitrust regulator has a very famous case against Facebook, where it actually used GDPR provisions to find an infringement of the rules concerning market dominance in Germany. And the big problem that they saw was accumulation of data. In the antitrust commissioner's opinion, not taking into account lawful grounds for processing to accumulate that data. Now, this is actually an ongoing case. Facebook has challenged that decision of the antitrust regulator. Now it's being dealt with in German courts. And also the Court of Justice of the European Union has been called to provide an opinion on the issue. So we will see, this to what extent we can rely on data protection rules to find anti-competitive behavior and sanction it or not. So yes, definitely convergence and a lot of points in common in Europe and in this executive order here.
Well, speaking of convergence, we'll swing back to Europe on the global privacy control, which seems to be, or a version of the concept of the global privacy control. I think they're calling it something else, not exactly the global privacy control, because but the same concept of a technical signal, but that would exercise some of the rights one has under European law. So we'll come full circle to see whether the convergence is not just on competition and thinking about data, but also on some of the technical solutions. And so let's switch to the global privacy control. Let me start with this, just as somebody a little bit involved in the question of choices around behavioral advertising for quite a long time. My view has always been that if you're on the industry side and you believe there is a role for data and advertising, whatever that means, targeting, first party, second party, advertising that is informed by data, and whatever license you as a publisher, an advertiser, intermediary think you have, there's going to be a range of concerns. And whether you are on the side of this is evil and should be banned and it's surveillance advertising, or whether you're on the side of I need this for revenue for publishers, my argument is there's some degree of use that some portion of your audience doesn't think makes sense, and provide them a switch that works. If your default argument is, I'm going to do some secondary things here with data, whatever they are, personalizing, robust, a little bit different kinds of targeting, provide a switch and make that switch work. Because when that switch doesn't work, then you've undermined your whole argument. And you know what? Most people won't use the switch because most of us are gone ahead and gone out of business. But maybe many will, and make sure that that switch works. That, in terms of advice to industry, is my best argument. And the Achilles heel, I think, that has existed for the past however many years has been that the switches don't work. They're hard to find. They don't do what they're supposed to do. I can't completely explain with 20 some odd years of bumping around ad tech exactly what some of the switches that exist today do or don't do, or how stable they are, and it undermines. So we need a reliable switch. And in some way, this is something that the global privacy control tries to solve. So before we get to things like default on or default off, let me bring in Ashkan, who has been a key driver of this recent incarnation. And let me maybe just throw out a couple of questions, because I know that folks who are watching it, who maybe aren't all about ad tech, but are, I don't know, I'm at a bank. I was having a call with some of the bank CPOs the other day, and this is not their bread and butter. They want to do what's right. It's a compliance risk. Of course, they advertise. And they're like, I don't know, it's a draft spec. There was a tweet from the AG what if there's a dozen different versions of this? Am I supposed to be watching, the AG's Twitter? Do I got to watch, Ashkan's Twitter to know what is the latest set of legal obligations? So before we get to sort of the nuts and bolts, can you help walk us through just the kind of the process, right? The AG put out a rule where he put this out as something that, he was able to build around the architecture of the law. Some industry or others want to argue about that, but it's there. And evidently, because of initially a tweet and now an updated FAQ, and perhaps it seems like it's also being raised in issues. It seems it's clear the position of the California enforcer that this concept is an enforceable obligation. But also because of this FAQ and maybe the tweet, we see evidence that this particular incarnation is judged to have scale, or but they don't have a list of here are the approved ones. We don't know whether if I wrote a plugin and I got a couple of prominent people to say they liked it, would it then be applicable? Like, what's the walk us through the right now this is the only one. Although maybe the DAA says they have one. I don't know. Help us with the process of whether people need to be looking for every possible signal that anybody might send, or only signals that get a tweet, or will there be a list, or just for the compliance geeks who are kind of just, I'll do whatever is wanted, but can someone tell me what I need to be looking for, and how the process will work to determine if somebody, I don't know, let's assume some trade group says, we've got a GPC and that's the one you should follow, and here's how it works. It only can be executed by doing backflips and triple flips. Do they also need to follow, another GPC? Floor is yours.
Sweet. And just to clarify, I don't have too much insight as to the AG's process. What I can say is that the California law, it's a unique situation, right? Because the California law requires that companies honor opt-outs, including through kind of global privacy controls and device settings, right? And that's what both the California law and then the rulemaking support. The challenge has been that initially, do not track was thought to have be satisfying this requirement, right? But the California AG took the position in their final statements of reasons that there's a California law that requires companies disclose what they do in response to do not track signals, and most companies say they ignore them. And so as a result, it's not satisfactory to require that do not track be honored, because most companies ignore them. So as such, I helped spearhead a number of browser vendors, plugins, and publishers to kind of come up with a reasonable standard or technical standard or specification for how the signal would work. And it's very much like do not track. It's a signal that your browser can send to indicate your opt-out preferences, and protocol that companies can look for. It's one line of code to implement if you use, for example, the IAB's USP API, right? So and Google and others, for example, have documentation on their webpage, for example, on reduced data processing, on how to comply with global privacy control if you're a publisher that receives it, right? Similarly, OneTrust, which is one of the largest CMPs, they have a one-click option for global privacy control, right? And so the standard that we propose is a very lightweight and technical specification, right? And I think to your point of while there can be many, and other people can come up with a standard, ultimately it's up to the browser vendors and kind of device makers to implement the control. All we're developing is the protocol, a specification for what is sent, which is a consumer request to opt out, and what a company can do to indicate their support, which is this file called the .well-known file. The real way to think about this, I think a lot of people have tried to complicate the issue in terms of compliance. The global privacy control, right, or even the intent of the law, as I understand it and I helped write it, was simply to allow consumers to set a setting that would invoke their opt-out rights, but the extension and the control function as if there was an automated agent in your browser that found the do not sell link on your website and clicked it for you. Right, that's all it's doing. So it doesn't touch compliance, which is one of the pitfalls of do not track. It doesn't specify, any more detail on the compliance side. Whatever a company is already doing, as they are required to under law for CCPA compliance, in terms of showing the button and permitting consumers to opt out, right? The GPC specification, all it does is invoke that opt out automatically for the consumer as required by law.
So speaking of required by law, the focus has really been California, but we now have a GPC concept in Colorado as well, right? How do you see it fitting in? I guess the same way, right? They have a mandate.
Yeah, I spoke with the California legislatures. I also testified in Alaska, and New Jersey are also exploring the idea of global privacy control. Florida, as if you recall, also had a global privacy control, and New York, prior to them going into, Senator Thomas's bill, before going into an opt-in standard, which even raised the bar further, had or was exploring the concept of a global privacy control. I think, to your point, it's important to, and I think there will be some nuances and differences in the law, but the standard is, or the proposed specification is extendable, right? And there is some benefit on convergence on at least the protocol, right? Otherwise, companies are left with the kind of insane burden of having to listen for and detect a bunch of different protocol strings that might be in different languages to speak. And on the flip side, for consumers, they might be confronted with a barrage of options and settings that they might need to engage with, which is actually problematic for consumer outcomes. So it is important, I think, to have some sort of standardization, and I think that will evolve with California being the lead. In fact, as you know, the California board, the CPPA, right? As part of the passage of Prop 24 CPRA, they will issue additional guidance on the requirements for the specification. But I think the fact that there is already wide adoption, some 50 million users have a browser or tool that has global privacy control, and a number of publishers, including like WordPress's hundreds of thousands of sites, and Cafe Media, and even Weather Channel, random publishers that are beginning to adopt GPC. I think the fact that it's being adopted widely and is compatible with, say, the IAB speaks to like maybe this is a good enough specification.
Let me grab the point that Robin Bergeon at the New York Times, not the media side, but the technology and trusted advertising and privacy side, and an implementer flags to us. There's been comment, including mine now and in the AG's, and on the GPC side, so there's a draft specification. And he points out that if the argument is it has to be a W3C specification for it to be recognized, then yes, of course, right? People have to implement first, and then it becomes a spec and so on. But that's not really what's going on here, right? What we have is a legislative or regulatory mandate saying when this sort of legal type thing happens, people indicate in a technical way that is accepted or global or something, right? I forget the exact language. Then you need to follow it. And so all of us lawyers are like, well, again, when does it become one plugin that one person wrote? We were talking before we went live about Taco, an effort that Chris Segoyan and others were involved with years ago to, a plugin that kind of kept your opt-out cookie stable so that you didn't accidentally clear it. Wasn't necessarily a mandate. It was a plugin. Here, I'd argue, well, certainly a number of prominent implementers if one was looking and assessing. But again, we are reading and assessing and saying, whoa, look at that. Meredith is on it, and New York Times on it, WordPress on it, right? But again, I'm thinking of my CPO at a global bank who isn't watching the list and saying, oh, there's one implementer, there are two, oh, no major browser, right? So leaving aside the W3 standards process, and again, you're right, this is the AG's problem perhaps to solve, to say, here's how we're going to decide and communicate to the world when we think something has scale that properly reflects. We'll keep a list, we'll take input, right? We're kind of used to some process of some sort, as opposed to, I don't know, right? A group declaring, we think we have enough, and then a tweet. So do you have a take, though, or maybe advice to the other states or maybe federally? How should implementers, right now, this is the only thing they can look at. But how should what should the process look like? I don't think we want to say only if it becomes a fully fledged W3C standard. It may never become one, right? At what point does something matter? Clearly this matters, but what should the process look like? Should FPF keep a list and say, here's what, here are the ones we think achieved enough consequence? What's your thinking?
I mean, it's a two-sided market problem, right? And at the end of the day, the emergence of a well-adopted standard will depend on both browser vendors and companies, right? And so that was my goal of trying to put forward a specification that is kind of independent of any company or browser vendor or specific interest, other than just satisfying the requirements in the regulations, which will get updated, as I said, under CPRA, but the requirements that it essentially allow consumers to communicate their opt-out preferences via a global privacy control. And it will be ultimately up to major browser vendors. So right now we have primarily only the privacy-preserving browsers like Brave and DuckDuckGo, and extensions like EFF and Blur from Abean and others that have implemented it. And that's the 50 million number worldwide. It will ultimately be up to Safari and Mozilla, who have been in talks with Mozilla more than Apple. Apple tends to be quiet on their intent, but it will be up to them, as well as Chrome, to implement these controls on the user side, and then it will be up to publishers and others to recognize these signals on the kind of the services side, right, on the websites and services. I will say, we look at, for example, the IAB's USP API, right? That is in fact not a W3C standard, but it's widely used by industry as the opt-out framework for CCPA compliance. And in fact, the GPC can plug in directly to the USP API. It was trivial, you can add literally one line of code that essentially says that if your website receives a GPC signal, right, that you enable the USP API privacy string, right, and send that to your third-party vendors, and they assume the role of service provider and agree under the framework that they propose, right? And so again, I think there's a little bit of overcomplication. Ultimately, the browser vendors will have to implement it and companies will adopt it. All I've done is specify like a language by which someone can express the preference, and all it does is, rather than forcing a user to click the button, the browser can click the button if the user has that setting enabled.
And Ashkan, this sounds a lot like something that is very familiar to technologists. It sounds a lot like, and you didn't use the phrase rough consensus and running code, but it sounds a lot like that, doesn't it?
Exactly. Exactly.
And that sort of language is not something that lawyers typically say, well, I can base a regulatory regime on, I can base a statute on, I can base a court pleading on. But for technologists, it's extremely familiar. And if you look at the way web standards have evolved over the years, going well back into the early to mid 90s, that approach has ended up being foundational for lots and lots of the web technologies we take for granted today.
Not even web technologies. If you look at things like, I don't know, safety features in hair dryers, or UL, universal certification for plugging in electrical outlets, right? They first started as widely adopted tools, even USB, right? Think about, or folks are old enough to remember VHS versus Betamax, right? It became adoption and then standardization. And right now we're at the adoption stage with some input from regulators and other jurisdictions.
Tara Cho raises a question that I know others have raised as well, right? And that's, there's sales that may be happening because you're collecting an email or you have account data and you sell. And then obviously there's this notion of a sale because of the digital technical cookies and other trackers. So one question that comes up obviously is that some people don't connect these. This is their ad tech and this is their account data. Presumably, if you can't connect it, you didn't get a signal, and you should just be clear and say, hey, we've got two different ways. We respect that for our cookie digital tracking, and if you want to opt out of account data or this and that, you've got to go through this process and be verified and so forth. Some people may have CRMs that link this together and maybe don't easily link it together, can link it together, potentially link it together. I guess there's a little bit of a gray issue there as to if you can and you're doing it, it seems pretty clear you better. If you can, but you don't, but it's in a log file.
I'll just jump in real quick. I know we were limited on time. Essentially, again, this I don't think is a GPC question. This is a CCPA question. What happens when someone clicks the do not sell link and you know the user ID, or what happens when a pseudo-anonymous user that has an account with you clicks the do not sell link on your website? Do you then prompt them for more information or for login? And the CCPA regs specify that the opt-out must be applied for the user if known, if not for the session. So that word if known does a lot of work there. If it's a pseudonymous identifier and you don't know the user ID, perhaps you just opt them out for that session or for that web session. If they've logged in, perhaps you opt them out for the web session and their associated email. Or perhaps if they click the button, you provide them with an interstitial that says, hey, we've opted you out for the session, but you might have an account. If you want to provide us with more account information, we will also opt you out for that account information. And so all three of those are valid. That's in the regs. I think that's independent of the GPC, but it's a valid question. Now,
you had a blog on the website of the CNIL, informal, but they host occasionally thoughtful things. Didn't mean that they supported it, but they don't obviously host things that they think are not of interest. And then we saw a proposal from a leading academic, and Noib was a co-partner in that. And it was a little bit different. It was focused a bit more on exercising the right to object. Let me ask you to comment on that. Is that connected? Is it inspired? And Gabriela, I'll ask you to sort of jump in on what the legal effect there might be and how it might plug into the e-privacy process or so forth.
So, right, I think you're referring to Noib and Max Strem's effort on the advanced data privacy control, right? And their proposed framework, and I've had conversations with Max as well. And, as you know, under European law, consent and withdrawal of consent needs to be specific and informed. There's additional rights and with regards to objections and processing. The proposal or the suggestion that I had not to overcomplicate things and reintroduce P3P, if you want to do additional throwbacks to TACA, not to go back and have a myriad of checkboxes that consumers have to interact with and control, to at least consider, for example, GPC as a proof of concept, which could, for example, reflect the objection, a right to object to direct marketing or withdrawal of consent for the purpose of behavioral advertising, as it would map to sale in the U.S. So we suggested that GPC could be this minor version of all the rights that you have under GDPR, but in fact GDPR does afford a great many more rights to objection and consent, and that's what the Noib guys have tried to articulate in their proposal, right, which I think would require a lot more hashing and fleshing out, but also would add a lot more burden to the user, right, because they're essentially having to configure this multi-factor consent system, which throws back to P3P, if people remember that.
Gabriela, your thoughts on how it may fit in the e-privacy or GDPR structures?
Just very quickly, the GDPR tries to be as tech neutral as possible, but I would say there is a specific provision under the right to object, particularly where the GDPR refers to automated means by which the data subjects can ask for the right to object using technical specifications. So this could be one of the options. So there could be legal effects for that. But again, it's open, right? Automated means using technical specifications. There's not a mandate for a specific specification. However, it will be taken into account, right, when it becomes entirely functional. And yeah, we're definitely looking at it.
And e-privacy too, right?
Yes, for the e-privacy directive, it will be taken into account. I'm sure, even though I don't recall specific language in the directive itself on technical specifications. But I know that in the discussions for the e-privacy regulation, so the discussions that are taking place right now, browser settings, in fact, are actually being considered as one of the options, and generally default settings are being considered as options as well there.
Well, my closing advice to friends in industry is the calls for bans of surveillance advertising in Europe are allowed. On the mobile side, you've already seen Apple determine that this is default off tracking for most of these purposes, unless you take an affirmative action, and it turns out that most people are not. Google has clearly said that cookie-related tracking, which is obviously a big part of what we're talking about, in the current way, will go away at some point. So the tide has turned, and one lifesaver, frankly, may be, well, if there's a switch that actually does something significant, which you gotta already legally give people because of the do not sell my info requirements. But if there's a switch that works, that's the best defense. And these are currently being constructed as default off. So that's a pretty big lifeline compared to what is coming down the line, where critics of notice and choice who aren't comfortable with just accountability are saying the answer is no, ban everything except for what is expressly allowed. Sherrod Brown's legislation, Ashkan was pointing out, some of the state laws, the intermediary, fiduciary type laws, that are being debated. So getting this right, figuring out how to embrace a good off switch is frankly a lifesaver if one can get to it with a way that creates the clarity that I think is intended. So thanks to all of you for joining on fairly short notice. Ashkan, always valuable to have your input and insights from the ground floor, and wishing everybody a really good weekend.
Thanks for letting me crash.
Bye all.
Thank you.
Thank you.